What is up, guys? Welcome back. I went ahead and bumped this up. This is the Idaho4 all new prosecution lies to the grand jury. Yeah, the prosecution did that. And Taylor argues 911 hearsay. Again, more with the grand jury in that. We have new documents. About time Hippler did this. So I'm sure all my people overseas are loving the fact that this live was bumped up. Normally on Sunday nights, we go at 9. We're going early. We're jumping into it. And the best part now is that we get to see how Ann Taylor actually wrote these motions. Okay. For example, in the Jared Bridegan case, Jose Baez, Diane Menashe, they have a sick team. Their filings and how they're writing things and straight to the point, using the examples like there's no ambiguity. That's just boom, boom, boom. Did Ann Taylor do that? You guys can be the judge. We'll talk about it. This is for the 911 call. So, as we know, a 911 call came in 8 to 9 hours later. So, Brian Colbert, by and through his attorney's record, hereby objects to the state's motion in limine to admit the 911 call and an accompanying transcript. The state relies on the exceptions to the hearsay rule and effect on listener. Mr. Colbert's objection is grounded in his constitutional rights, which is the 5th, 6th, and 14th Amendment and Article. So touching on everything, going all the way up to federal and as well as the Idaho Constitution. The state correctly recognizes, so the 911 call, here's what Ann Taylor said. The state correctly recognizes the statements on the 911 call are hearsay. Idaho rules of evidence make hearsay inadmissible unless it meets one of the exceptions. The state identifies 2 exceptions to the rule against hearsay and further recognizes all parts of the statement must meet the exception. The state must provide foundation for an excited utterance. The state alleges that statements fall within the excited utterance or present sense impressions, exceptions to the hearsay rule, or are not testimonial. The state distinguishes and identifies only one statement but claims the rest of the statements fall within the exception of the present sense impression. What this means is hearsay is fine. You can use hearsay if it meets an exception. Otherwise, hearsay is out. So they've cited here the excited utterance. So excited utterance has 2 requirements: an occurrence or an event sufficiently startling to render an operative or the normal, like, so when somebody, if you're in a movie theater and somebody's yelling fire, 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 something like that. Okay. That's hearsay, right? But it's an excited utterance and it happened at the time. And so that would be permissible. So again, an occurrence or an event sufficiently startling to render an operative the normal reflective thought process of an observer. 2, which means and, the statement of the declarant must have been a spontaneous reaction to the occurrence or event and not the result of reflective thought. Has to happen right away. So, again, citing a case here out of Idaho, we consider the totality of the circumstances, including the amount of time that elapsed between the startling event and the statement, the nature of the condition or event, the age and condition of the declarant, the present sense or absence of self-interest, and whether the statement was volunteered or made in response to a question. So this 911 call did not come at 4:30 in the morning when DM and BF communicated with each other and ended up in the same room. This 911 call came 8 hours later. This call came after DM and BF each made calls, corresponded through text and other messaging to family and friends. The 911 call came only after friends arrived. And guess what? I would have said, and they were told to call 911. Their own interviews say that Hunter told us to call 911. Now, this is what should blow everybody's mind because we get a little cross-reference into the grand jury. So, BF initiated the 911 call, and thereafter the phone was passed from person to person. The state lays out only one statement as an excited utterance. The statements of EA, Emily, when the phone was passed to her. Oh, and they saw some man in their house last night. Yeah. The state claims these words are an excited utterance because they explain why Xana was passed out. What? The state, like, that's insanity. That's a lie, and they know it. How can the state even claim that? The state claims these words are an excited utterance because they explain why Xana was passed out. The state fails to take into an account why that statement was made. The same transcript and same page reflect the dispatcher asking exactly what was going on. EA stated, one of the roommates who's passed out and she was drunk last night and she's not waking up. Either BF or DM said, no, we saw. After that prompted EA to, told the dispatch about the man they saw. Thereafter, the phone was handed back to DM. The statements by EA do not fit within excited utterance exception. She first states she is reporting a roommate who was passed out from drinking and not waking up. What? No, we don't know what happened. We don't know what happened. Come on, Ann Taylor. What are you talking about? The call to 911 is something is going on in our house. We don't know what's happening. Right? Again, whatever. She first said that she is reporting a roommate passed out drinking, not waking up. She then states that they saw the man in the house. Blah blah blah. EA did not have firsthand information and is repeating what DM and BF told her. 1,000%. It's all hearsay. 1,000%. All of the statements made by DM and BF must be analyzed under the applicable framework for excited utterances. So, in Mr. Culver's response to the state's motion limine, re the text messages and testimony, he objects, in part based on completeness of the record, but also because a more complete record weighs against the state's motion. The phone activity of the DM and BF shows the statements on the 911 call are not an excited utterance. The phone activity of correct. So then you go down here and she says 1 exhibit, texting objection 1 and 2. Are Mr. Culver's exhibits prepared from DM and BF phone records? They are incorporated here by reference. The phone activity is more extensive than a few messages between DM and BF. Phone activity did not stop once they were together. It did not begin right before 911 was called. The 911 call was not contemporaneous with DM and BF's stated awareness of something happening in their house. You want to know why? Another thing, DM says that she thought Xana was passed out drunk at 3 o'clock in the morning, like whenever she went downstairs. Like, what? This is crazy. Again, the 911 call was not contemporaneous with DM and BF's stated awareness of something happening in their house. It's just not. 8 hours passed until they called for friends to come to the residence. An excited utterance is a statement that is made while under the influence of an event. The 911 call and statements contained therein came after conversation, calls, texts, internet surfing, and other phone activity. How come there's no steps here? Like, where's that data? Present sense impression. The state claims most of the statements in the 911 call meets the present sense impression exception to the hearsay rule. The state says this so because they all saw Xana unresponsive and were told to call 911. Idaho Rule of Evidence 8031, present sense impression, a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. The only possible statements that qualify are those regarding Xana being unresponsive. Statements regarding what DM and BF claim they saw 8 hours earlier are not contemporaneous in time. Correct. Reviewing the grand jury testimony shows the state misplaces reliance on at least some of the statements about Xana. The state ignores previous sworn testimony when it claims the 911 call contains present sense impressions because the declarants were observing Xana. And then look at this. They have to redact this because then they are citing what was said at the grand jury, which is sealed. But what this means is Ann Taylor, this is her way of trying to call out the state that's saying, hey, do you guys forget what y'all claimed and what was testified to at the grand jury? And now you're trying to claim something different? Because this is the testimony at the grand jury, you know, that we all fought against because it's like, this is crazy shit, right? So here, Ann Taylor's basically saying you can't have it both ways. So are you just dismissing what they testified to at the grand jury? Because what you're arguing here now is opposite of it. Again, reviewing, this is why Ann Taylor is saying, reviewing the grand jury testimony shows the state misplaces reliance on at least some of the statements about Xana. The state ignores previous sworn testimony when it claims the 911 call contains present sense impressions because the declarants were observing Xana. And then basically what I think this has to do with is that they did not first observe Xana right before the 911 call. The state has not identified what exception to the rule against hearsay apply to which statements, with the exception of the previously discussed statement. Review of the record and background show neither exception applies. So they're basically saying it doesn't fucking matter which way they go. It's out. Like your little argument here, like it shouldn't fly either which way. The state relies on the conclusion reached by Judge in denying Mr. Culber's motion to dismiss the grand jury indictment. Mr. Culber disagrees with the conclusion and the state's reliance on the findings. So they disagreed with his conclusion and the state's reliance on the findings. Then, Judge's findings do not include a full analysis of the applicable exception accompanied by the background information. This court is not bound by Judge's ruling. the law of the case doctrine applies, where an appellate court pronounces a quote unquote a principle of law necessary to the decision. This court has discretion to hear and decide the issue or issues presented before the court. The court, as the trial court, discretion to change its own pre-trial rulings, especially evidentiary rulings. So the court, as the trial court, discretion to change its own pre-trial rulings, especially evidentiary rulings. And then boom, that's it. Like this morning when I'm reading stuff to you guys and I'm saying here, when you got somebody like this, Kirsten, who is writing like, see iPhone affidavit at 7. Instead, without explanation, the affiant sought records for an account associated with a different phone number ending in 4571, without any allegation linking that number to an iCloud account or to either crime. The same is true for the Google warrant, which similarly fails to allege Ms. Gardner used the Google suit of production to do anything related to either offense. Like, I just feel like Ann Taylor's writing, or who's ever writing these, they're not connecting the dots. They're not laying it out. It's not good. The 911 call contains little that fits within the exception to the hearsay rule. The statements that they saw a man in the house are testimonial in nature. Witnesses will need to be in court to testify to satisfy the constitutionality protected areas of confrontation. And remember when like we're all wondering like, well, I'm over here wondering, why are they even asking for this? If all these people are testifying, what's the problem here? And it's like they want a pretrial ruling to know how these people can testify and what questions they can ask these people. But Ann Taylor's over here like, she doesn't think that portions of this 911 call should be played because it's already starting. It's just a narrative. It's already just going into like this narrative. Okay. And it's like everything with Jennifer Drake is the same way with the 911 call. So that 911 call gets to be played, and which is like this narrative that somebody was shot through the window. She's putting that, versus that it was shot out to stage the crime scene. So the confrontation is the 911 call contains little that fits within the exception to the hearsay rule, or the rule against hearsay. The statements that they saw a man in the house are testimonial in nature. Witnesses will need to be in court to testify to satisfy, basically, that we get to confront this witness. You don't just get to play this 911 call and it just be what it is. Now, transcript. Mr. Culber raises the same objections to the transcript being admitted. If the transcript is admitted, the court should only admit a version that is certified by a court reporter. Mr. Culber has a certified transcript prepared and provides it as an exhibit to this motion for use should the court allow the transcript to be admitted. Mr. Culber objects to the state's motion and urges the court to deny it. Testimony in open court and subject to the adversarial process best protects Mr. Culber's constitutional rights. So they're just like, and I'm just like, Anne, why are you just always beating around the bush? I don't fucking get it. I don't get it. Anyways, I think everything to do with the 911 call is shit. Everything is shit with that, right? Yes. How does a 911 call not come in for that long? But also, you have to be told to call 911, and you don't even know why you're calling 911. And how this is a no motherfucking brainer to possibly combat how you have a position on this on the other side. How you would even be asking for it is, I mean, I get it. You're throwing everything here, throwing everything at the fucking wall, seeing what sticks, but it's nuts. It's absolutely nuts. And you guys, when I saw all that redaction for the grand jury stuff, I said, oh my God. I said, that sucks we don't get to see it, but we have now even more proof that what they were claiming and what they testified to at the grand jury is not the way that they're trying to explain it now. And it's like, here, they testified this way at the grand jury, but we're going to ignore that they ever even testified. And this is our argument here for this to be admitted. Mind blowing. It should be mind blowing to everybody. Next up, we have this is, oh, they just stipulated that his cell phone wouldn't be in, so that's whatever with that. I want the not that one. We want the Big Daddy here. Let's see. Nope. Nope. Yes, this one. Okay, here it is. We're going to talk about how they wanted to use this 404B evidence. And then we're going to get into Maury's shit. Comes out Brian C. Kohlberger, by and through his attorney of record, and hereby objects to the state's notice of intent to use 404B evidence. And it was filed February 4th of 2025. 404B, 2, the state intends to present evidence of crimes, wrongs, or other acts. Specifically, the state intends to use the video of a traffic stop on August 21st, 2022, and the citation regarding the same traffic stop for the purposes of proving defendant's identity, vehicle, address, and phone number. For the reasons set forth below, Mr. Kohlberger objects to the use of this evidence. Now, this is the argument. The state misconstrues the identity aspect of Rule 404B because the August 21st, 2022 traffic stop bears no resemblance to the crime charge and should be excluded from evidence. So when the state presented the video of a traffic stop on August 21st, 2022, and the corresponding citation as evidence to the grand jury, a limiting instruction was given stating that this evidence is blank, 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 blank. And I'm like, oh my God. Really? And this is what the ruling was from like the sealed order denying motion to dismiss the indictment on grounds of biased grand jury, admissible evidence, lack of sufficient evidence, and prosecutorial misconduct. I'm telling you, this should have been kicked. That's the bigger issue here. The state misconstrues the identity aspect of IRE 404B. Evidence of prior misconduct is relevant on the issue of identity when the evidence demonstrates sufficiently similar as well as distinctive characteristics or patterns between the prior misconduct and the charged crime. And so it's like, how do you guys think that you can bring in a traffic stop that has nothing to do, like Brian Kohlberger is being charged with murder? This is irrelevant. How are you getting this in? Well, because we're labeling it as prior bad acts. No, they basically want to do this so they can do what? Let's be honest. They want to be able to show the jury Brian Kohlberger in a white vehicle, the white Elantra, right? And And the argument is, well, you have other ways to testify to this. Okay. So here, citing some cases, State versus Levitt says that, and citing State versus Porter, when the other acts evidence is introduced to prove identity as proposed by the state in this case, the characteristics of the other crime or act must be sufficiently distinctive to warrant an inference that the person who committed the act also committed the offense at issue. Neither the video of a traffic stop on August 21st, 2022, nor the corresponding citation are similar to the charged offense, murder. And then they're citing United States versus Scram and saying that conviction was reversed and remanded where video and audio evidence of a defendant's prior encounters with police was offered to prove identity, and admission of such evidence prejudiced defendant's substantial rights. The state has other ways to prove Mr. Kohlberger's identity without using a prior bad act. Okay. And basically, like, why aren't we just calling a spade a spade? And so I have an argument for this, but Ann Center doesn't make this argument. Rule 404B excludes the reference to the August 25th, 22 traffic stop as evidence in this case. Evidence of a crime, wrongdoing, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with character. Permitted uses of other crimes, wrongdoings, or acts is when the evidence is being used for another purpose. So, like, permitted uses of other crimes, wrongdoings, or acts is when the evidence is being used for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. The prejudicial effect of character evidence is that it deduces the jury to believe the accused is more likely to have committed the crime on trial because he is a man of criminal character. Okay. Character evidence, therefore, takes the jury away from their primary consideration of the guilt or innocence of the particular crime on trial. The drafters of IRE 404B were careful to guard against the admission of evidence that would unduly prejudice the defendant, while still allowing the prosecution to present probative evidence. So admissibility of misconduct evidence is subject to two-tier analysis: State versus Anderson, State versus Field, State versus Grist. First, the court must determine that the evidence is relevant to a material and disputed issue concerning the crime charged. How does it get past that? How is this evidence relevant to a material and disputed issue concerning the crime charged? Second, the court must determine that the probative value of the evidence is outweighed by the danger of unfair prejudice to the defendant. Why do they even need to use it? Right? Rules 401, 402, and 403 exclude the traffic stop evidence as irrelevant and unfairly prejudicial. In addition to exclusion under Rule 404B, any reference to the video and citation related to the August 21st, 2022 traffic stop must be excluded as not relevant to the allegations in this case. That's just what I would think. Think about it. Think about any other case out there, right? When are we ever introducing someone's traffic stop? In any other case, When? Whoop, 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 whoop. Welcome to the new members. What is up? Wit, Mitts, Hoffy Master, nothing but loves and stars and bars. And Amanda, bizarre that Emily has Instagram post stories where she references Xana as her roommate multiple times. They were roommates before. And then when she moved in that house, so I've just never heard of, hey, let me just show you guys a time when this person got pulled over. So let's be honest here. Why do they want extra emphasis on the fact that this man drove a white Elantra? Like, it's going to come out that he has a white Elantra because when they ran his information. So what does it matter? You know what I mean? So how would this not be considered overly prejudicial? Right? Like, what is this helping with? So evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. And B, that the fact is of consequence in determining the action. Whether a fact is of consequence or material is determined by its relationship to the legal theories presented by the parties. So again, the state's theory is that somebody drove there in a white Elantra, right? And like circled around and then committed the homicides and then left in that Elantra, right? That's their theory of the case. In this case, she says, evidence that Mr. Culber was stopped for a traffic violation on August 21st, 2022 is not reasonably tied to crime charged and must be excluded from evidence as irrelevant and not material to the crimes charged in this case. How do you write that after you say this? Whether a fact is of consequence or material is determined by its relationship to the legal theories presented by the parties. Under IRE 403, this court may exclude character evidence if its probative value is substantially outweighed by a danger of one or more of the following. And you guys, none of this, doing this ahead of time is great, but when Ann Taylor's in there, she's going to object and say, objection relevance. I'm going to be I object to the relevance of even bringing up this officer to ask him if he pulled over my client. Objection relevance, sidebar. How is this relevant? Make fucking Hippler, how is it? What's going on here? How is this relevant? How is this going to show the jury that because he got pulled over, he committed a crime of murder? Again, 403, this court may exclude character evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time. This is a waste of time. Or needlessly presenting cumulative evidence. Yep, I could say it's needlessly providing cumulative evidence. Yep, wasting time, undue delay. Yep, This rule requires the court to balance the probative value of the evidence against the danger that this evidence may be unfairly prejudicial. And I just don't understand. The guy has a white Honda Elantra. Like, that's not a secret, okay? The issue is that you're trying to say that the car that's circling around is a white Honda Elantra. But that's speculative, right? Especially what I would be arguing here is that we have these dueling theories. And my theory is that was the undercover's vehicle, okay? And we have an undercover plainclothes officer who has come out in a report labeled November 15th and claimed basically ownership. And not only do we have him saying that he went around and it was right before the Banfield shit, right? We also have a woman named Molly McMichael, who basically an eyewitness to who the driver was, which looked like fucking Tisdall with the spiky blonde reddish hair, okay? Whether or not she saw anybody else in the car is irrelevant because they're doing a plainclothes operation where they're in and out of their vehicles. Doesn't matter, right? We have somebody claiming this white car and he's in a Fusion, Your Honor. So we do have dueling fucking interests here. And so we're not going to overly prejudice my client for them to show this fucking video. Give me the relevance of it. How does this pertain to murder? Now, even assuming this court concludes that the character evidence discussed in the state's 404B notice is somehow relevant, whatever minimal probative value it may have is substantially outweighed by the danger of unfair prejudice and confusion of the issues. That's what they're saying. Unfair prejudice is prejudice that tends to suggest a decision on an improper basis. The character evidence identified in the state's 404B notice has no nexus to the criminal charges against Mr. Kohlberger. Yeah, what does that have to do with what? Exactly. This evidence confuses the issues. If the video and corresponding citation for the traffic violation on August 21st, 2022 is presented to the jury might well believe that Mr. Kohlberger is guilty of the crimes charged because he is a person prone to wrongful behavior. I'm like, wait a second, excuse me, that's what you wrote, Anne? Oh my God, what? The jury might well believe that Mr. Kohlberger is guilty of the crimes charged because he is a person prone to wrongful behavior. And then that's the argument where no wonder Hitler is over here saying, I don't think the jury is going to say that the man, because he got pulled over for a seatbelt violation, that he committed murder. I don't think the jury is going to confuse those two. And I'm over here like, I cannot believe that was Ann Taylor's argument. I'm sorry, but that's crazy. The argument here is that there is at issue what type of car that is, right? And at issue is that the person is even in a car committing a crime. Okay? Mr. Kohlberger's vehicle came back and there's not a speck of blood in this vehicle. This is going to what? You're not going to try to get in 404, 403B evidence, okay, to misuse the true purpose of it. What you're trying to say is identification. Get fucked. No, you want to show the jury this, that you can show the jury my client in a white vehicle, okay, that is similar to the one that you're claiming is suspect vehicle 1. In Your Honor, they want to do it by using a video of a traffic stop that has nothing to do with this case. Ann Taylor, her argument was fucking weak as balls. I mean, wow. The argument is, I mean, geez, whatever. I would be objecting at trial. I mean, and I don't know how you're calling somebody to the stand to talk about the fact that, because it had no bearing on, it wasn't part of your, this isn't how you found the suspect, okay? This was all after the fact. And it's just bad. Bad. I mean, if you think that this is how Jose Baez and Diane Menashe would have argued this, I would love to ask them that. I just think it's a horrible argument. As a consequence, there is a danger that the jury would reach a decision on an improper basis due to evidence that is unfairly prejudicial. Well, not based on your fucking argument. I think it is unfairly prejudicial. But it goes to competing theories of the case. And they shouldn't be able to speculate on what the car is, right? You're supposed to have like a expert. Whatever. Admission of irrelevant evidence violates due process under the federal constitution. I mean, Anne, why did you bother doing any of this just to say take a plea deal? The rule against the use of character evidence to show conformance with or propensity is a historically grounded rule of evidence. The evidence here is even more remote to the alleged criminal conduct than that described in McKinney. The possession and use of a knife by the appellant in the context of his mother's homicide. There is no permissible inference that could be drawn from the character evidence identified in the state's 404B notice, and therefore admission would violate Mr. Kohlberger's due process right to a fair trial. I don't know. But maybe you guys can decide if you think Ann Taylor did a hell of a job. You know, I just don't see it with that argument. But that was written by Elisa Mathis. Now, moving on to Exhibits 1, 2, and 3 in support of objection to state's motion in limine AT&T timing advance records. There's only one thing that we haven't seen of this. And this would be the beginning part. So this is how she wrote this, though. So this is what gets unsealed. And I'm just like, this is, again, I just think a bunch of crap. Comes now, Brian C. Kohlberger, by and through his attorney of record, and hereby files under seal Exhibits 1, 2, and 3 in support of their objection to the state's motion in limine RE. So this is we're filing, here's our Exhibit 1, which is the email chain between law enforcement, Ashley Jennings, and Special Agent Nick Balance. Exhibit 2 is the AT&T search warrants, and Exhibit 3 is the AT&T mobility carrier request form. Okay? This just gets unsealed, and here is all that pretty much matters because the rest we've already seen. So this is from on 11/15/2022. We're going to go to the second page because you have to read it like backwards, I believe. Because as we can see here, Sunday, November 13th at 6:29 p.m. Think about that. Lawrence Mowry sends, so he wrote, it's ler3@tmobile.com, okay? And now this is their way of saying that this is how she was going to use the fact that there would have been a preservation order, okay? So here, from sent to Lawrence Mowry. And so see how it says RE like that? It's because it's a reply to Lawrence Mowry. And he was applying for a search warrant or subpoena search warrant. And it was for this tower dump. Okay. And this is the extension form request. And caution, this message originated from outside the city of Moscow's network. So just, caution. See that? Detective Lawrence, the requested time frame for the tower dump is too broad. Please narrow down your request time frame requested on the form and resubmit for processing. I.e., if the incident occurred at 4, to ask for something like 3 to 5 or 3:30 to 4:30. So right here, 8:07 was sent. So from Lawrence to LER. And I'm like, 807. Hello. After speaking with one of your helpful LE specialists, please accept the following extended form for the review and processing for tower dump towers providing coverage to. And then right here, this is what he asked. For 12 hours prior to and following the incident time of 4 a.m., if there are any concerns or questions, please feel free to contact me, Detective Mowry. After speaking with one of your helpful LE specialists, what? Please accept the following. Boom. He was requesting 12 hours prior to and following the incident. And somehow this got denied, right? And it was like, no, you can only do like 2 hours, like 3 to 5, you know? So hang tight. Then if you look at this, hold on one second. If you look at this is Sunday. So that's the response sent at 6:29 p.m. That's why I'm just like, man, this doesn't make sense to me. 8:07 p.m. Like, how can you be responding to me at 6:29 p.m. when I wrote you at 8:07 p.m.? Anybody see that? Like, this is what starts it. Because the person's response is the requested time frame for the tower dump is too broad. Please narrow down the request. Like, you want 12 hours. But how is that 6:29 p.m.? If Mowry did not send it out to them until 8:07 p.m. You guys see that? Now remember, it's coming from. No, if anything, if you're West Coast, okay. So if it's, let's just say he wrote this at 8. If he wrote this at 8 p.m. and let's say that he's writing it even if it was like to somebody on the East Coast, then it's going to be 8 on the West Coast would be 11 p.m. on the East Coast. If you're writing to somebody that's in, Mountain, that would be, your one off then. So anyways, let's move on. He wanted 12 hours and they were like, no, you can get this. Then he, on 11:15, hello again. Thank you for your quick response regarding this exigent circumstance tower dump. I was wondering if it would be possible to request the timing advanced area search for all records and unique device/user identifiers pertaining to timing advanced location information during the previously listed dates, times, and geographical boundaries. This information was not included in the tower dump records provided. See that? If I need to provide another request form, affidavit, or documentation, please let me know. And so I said to myself, oh my God, right? This is what they're using. What they're using is to say, when you would have gotten a return back, just like how you're asking, hey, you guys didn't put this, you guys didn't provide this. information. Do you need me to fill something else out? But then check this out. From Lawrence Mowry to Nick Balance, November 15th at 4:03. And I'm like, wait. So this happens first. See this? Then the same day, AT&T for review from Lawrence Mowry to Nick Balance. Subject, external email. AT&T Tower Dump. Do we need to use Nilos instead of advanced timing, or is advanced timing generic enough to use? L. Well, from Ashley Jennings. This was at 1 p.m. So I'm like, oh, wait a second. Ashley Jennings gets involved. Ashley Jennings writes to Lawrence Mowry. Caution, this message originates from outside the city of Moscow's network. From Ashley Jennings to Lawrence Mowry is from outside the city of Moscow's network. What? How's this look? Question mark. Ashley to Lawrence. Then Lawrence to Nick Balance. AT&T for review. Do we need to use Nilos instead of advanced timing, or is advanced timing generic enough to use? Because Ashley Jennings is the one that used the timing advanced lingo. Okay. Then she sends it to Lawrence Mowry. Then Lawrence Mowry sends it to Nick Balance. Then it says Nick Balance to Lawrence Mowry. Caution, this message originated from outside the city of Moscow's network. From Nick Balance to Lawrence Mowry. I thought they were all co-located. Like, what the fuck is going on? It says, Nilos became location database of record, or LOC DBOR, a little while back. List that and timing advance, since both are applicable with them now. Signed. Boise Resident Agency. Then Lawrence Mowry to Ashley Jennings at 4:25 p.m. After that was sent at 3:10, but that's 3:10. See, 4:03. I mean, it's just a big jumbled mess, but Ashley, AT&T has specific verbiage that used to be Nilos, but apparently they changed it to bump. Can we add that to the advanced timing section? I got the attached back from Nick, FBI, with his recommendations. And this is where it's like, you're co-located. The fuck you are. I don't believe that they're co-located because it doesn't make any sense with the time, with the times that these emails are being sent. That's number one I see. Number two is, why would you, if this guy's co-located with you, why is it saying that it's originating outside? I don't know. I don't fucking know. If you're on the same network, and it's like, oh, we brought our little truck out there and blah, blah, blah. Yeah, but you were inside. That's why Ann Taylor was asking those questions. Like, where was he at? He was in Moscow in the room. Again, welcome, good evening. Moscow is not the county. What? Latah is the county, and Moscow is located in Latah. Pretty much at 4, let me just tell you what happens. Anyways, right? All this bullshit, right? But here, they know the lingo, and so this is what they're using. This is what Ann Taylor is using as an exhibit, right? Well, we don't have yet the motion that she wrote up. I mean, but I thought we did. Did she not file it under seal? And then here's the this one's for the search warrant and authorizing what was this? The pen trap and trace. right here, including RTT and locked door reports or similar generated location information, timing advanced and or true call or other information tending to reveal the proximity or precision location of the device associated with the target address. Unredacted? Further, there is probable cause to believe that the use of a pen, registry, and trap or trace device will lead to law enforcement acquisition of real-time pen, registry, and or trap and trace information, and that this information would be evidence related to the crimes of homicide, which are currently under the control of AT&T. What? How does that help? I don't understand. The court finds that Brett Payne, investigating officer, and Ashley Jennings, senior deputy prosecutor, has certified to this court that the information likely to be obtained by such installation and use is relevant to an ongoing criminal investigation. How are you just writing only that? Pursuant to IC 18-67222, the court finds that the identity of the person to whom the phone is leased or in whose name is listed to the phone line to which the pen, register, or trap and trace device is to be attached is Brian Koberger. The identity of the person who is the subject of the criminal investigation is Brian Koberger, who resides this phone number, this. And the physical location of the phone is currently Albrights, Pennsylvania. Then why are you doing a pen, trap, and trace if you know where the phone is? If you know where he's at. I thought they were trying to find his location. They didn't know where he was or something. And it's like, what? You know what this tells me, guys? They wanted to know who he was in communication with because they believe he didn't commit this crime alone. You understand that? Alone. This is what you do when you want to what are they doing here? Like, right? I don't know. Did they think he didn't commit this crime by himself? That the above identified investigators and investigative agency or agencies are authorized to install and use a pen registry to register, filter, record, and decode electronic or other impulses, including but not limited to dialing, routing, addresses, blah, 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 blah. IP addresses are not okay. And further, whoopsies. That the above identified investigators authorized to install use of trap and trace device to trace, identify, register, filter, record, and decode. Content information otherwise transmitted to the target address or other identify the originating numbers. Mm-hmm. To use self-site simulator in connection with the target address. Okay. On a 24-hour basis, the listed investigative agency with all information tending to reveal or to lead to the learning the location of the device. What? Necessary to locate the device using the target address in real time, and that the above listed service provider and any other person served with this order shall, upon request by law enforcement, assist by providing on a 24-hour basis the listed investigative agency with all information tending to reveal or to lead to learning the location of the device using the target address, including positions information such as GPS, longitude, latitude. They were already... What? You guys, this doesn't make any sense. They were already following him. They already knew where he was. They didn't need to locate him. This is on the 23rd. This is what they did to Molly. What are the returns on that? It is further ordered that the investigators and investigative agencies using cell site simulators shall take all steps necessary to limit collection of any information or metadata to the target address. Take all steps necessary to permanently delete any information or meta collected from any party not specific or specified in this order immediately following its collection, and must not transmit, use, or retain such information or meta for purposes whatsoever, and must delete any. It is further ordered that the listed service provider and any other person or entity providing assistance compensated by the above identified investigative agencies for reasonable expenses incurred. It is further ordered that this order is effective on December 23rd, 2022 at 4:53 p.m. You remember they asked somebody what they testified to and said, what did Nick Balance rely on? The returns of 4:33 a.m. 4:53 p.m. That's to get the pen trap and trace. Now, this was to get the search warrant for any peace officer authorized to enforce or assist in enforcing the law enforcement. Brett Payne having given me proof upon oath this day showing probable cause, establishing grounds for issuing a search warrant and probable cause to believe property consists of certain evidence regarding the investigation into the crimes of homicide, is on the AT&T account associated with the phone number blank between 12 a.m. on November 12th and November 14th, 12 a.m. Information should include user account information. Okay, so let's see the date. And they put timing advance in here just so you know. Like they call detail records, including, it's written right. The timing advance gets put in here. Location information to include any estimated or known longitude and latitude of the cellular device's current location or approximate location information received by cell towers in reference to direction and distance from the tower. A device may be located, timing and translation. Location information can be form of historical records. This would include any reports of device activity that would include approximate latitude and longitude of the device and the timing and the time of the activity, estimated margin of error. And those are right here. See this? Boom. Where is that ship? Cloud data, all text messages, AT&T, Global Legal Demand Center. And this is what just doesn't make sense, is that Global Legal Demand Center is what they sent everything to. And this was the argument that they can't get timing in advance, that that Global Legal Demand Center did not provide those. But then how did you ever get them to begin with? Please provide this information to Brett Payne. Okay, Brett Payne. And then it says, so we did this at 10:03 a.m. This was the first one. The first warrant is at 10:03 a.m. on December 23rd. And then this is for the where's the date on this stupid thing? 12:23 at 5:53 p.m. Mountain Standard. So that's 4:53. What do you call it? But guess what? They didn't put this in until the next day. They were getting updates every 15 minutes. GPS pinging every 15 minutes. Event-based location. Additional contacts. Hit all those people up. Thanks. Search warrant and authorizations, installation, and use of. What is this? Is this a return? Look at this further. There is probable cause to believe that the use of a pen register and or trap and trace device will lead law enforcement acquisition of real-time pen register and or trap and trace information, and that this information would be evidence related to the crimes of homicide which are currently under the control of AT&T. How would that lead to the crimes of homicide? They knew, you guys. The physical location of the phone is currently in Albrights, Pennsylvania. They act like, oh my God, he fled. They knew he was at his parents' house because they looked into who he was, and the IGG were related back to. I mean, this is ridiculous. This is all lies. And whatever, man. Thank you, Megan. Megan Marshall. Where's the other one? $10:03, and then the second one was at 4. Like what? Whatever. Ridiculous. Fucking ridiculous these people are. Next is that one. No, not that one either. Inconclusive data. Okay. We're going to go to this inconclusive data shit. Inconclusive data. Comes now Brian C. Colbert, invited through his attorney of record, and hereby moves this court for an order limiting testimony about the statistical analysis of item Q 13 point, the fingernail scrapings. Okay. Allowing such testimony would violate Mr. Colbert's federal and state constitutional rights to due process, a fair trial, effective assistance of counsel, and confrontation of witnesses. This motion, blah, blah, blah. The requested limits are made to secure fairness in administration to the end the truth may be ascertained and proceedings justly determined. Further, the above requested matters are ripe for consideration by the court pursuant to IR 104 based on the existence of issues that involve preliminary questions of admissibility. Statement of fact. In the grand jury, so in grand jury testimony, how are we able to know about this? But we couldn't know about the other thing. Jane Miller testified as to the results of testing done on item Q 13.1, a swab of the left fingernail clippings from Maddie. The data consisted of 3-person mixture. 3. The statistic, the likelihood ratio, was calculated assuming that Maddie Mogan was a contributor to her own fingernails. Miller testified that Maddie Mogan has followed as this DNA profile is at least 77 million, whatever, times more likely to be seen if it resulted from a mixture of DNA from Madison Mogan, Kaylee, and an unrelated randomly selected individual than if it resulted from the DNA from Madison Mogan and 2 unrelated randomly selected individuals. The data from that sample was inconclusive as to Mr. Colbert. Grand jury transcripts at 365. Miller testified that inconclusive means that an analysis is unable to say one way or another, or not Brian Colbert is included in the mixture. Miller went on to explain that the likelihood ratio for Mr. Colbert was 0.0469 and that any number less than 0.01 supported exclusion. What? The use of misleading language confuses and misleads the finder of fact and is barred by the rules 402 and 403, as well as due process in the evidence is overly prejudicial. The erroneous admission of irrelevant and prejudicial evidence will offend due process when it renders a trial fundamentally unfair, motherfuckers. Here, expanding beyond the language of the report would prejudice Mr. Colbert in that it might allow the jury to infer that the inconclusive data would mean that he might be included. LRs are different from traditional statistics that courts and juries are used to seeing and hearing. The likely ratio is a comparison of hypothesis. It is not a statement of identity or probability of identity. It simply asks the question, given the data, which hypothesis tested is more likely? For items Q13.1, both hypotheses tested for individuals or for each individual assumed that Maddie Mogen's DNA was present. So when the lab generated an LR laid out above, the hypotheses tested were MMKG and one unknown unrelated person versus MM and 2. This comparison was done for all of the individuals listed in report number 7 and for Mr. Colbert in report 26. At the Idaho State Police Lab, any number greater than 100 is considered a conclusive resulting indicating inclusion. Any number less than 0.01 is considered a conclusive result indicating exclusion. Thus, if a likely ratio falls within a range of 0.01 to 100, the lab cannot draw any conclusions that the data is reported as inconclusive. This is what they gave the grand jury, though. That's crazy. In her testimony, Miller did not provide a full context to the analysis. The lab reported a series of likely ratios for item 13.1, including a likely ratio of 0.399 for Jack Decor, 0.485 for Cole Barenberg, and 0.20 for Xana Kernodle, and 0.0233 for Bethany Funk. The lab report number 7 at 3. All of these individuals sit in the same shoes as Mr. Colbert, namely that the likely ratio is exclusionary but falls in the range of inclusive. Of interest is that when a likely ratio is calculated for Ethan Chapin, of interest, the lab reported 3.33, you guys. Ready? Thus, Mr. Colbert's inclusive likely ratio is similar to almost every other person for whom an LR was generated, and focusing on his inconclusive LR would mislead the jury. In that it implies that the likely ratio means that Mr. Colbert's DNA might be present in the sample. So let's talk about this. When was Ethan found? Who found Ethan? What did Maddie maybe see? You guys, look at that. Of interest is that when an LR was calculated for Ethan, the lab reported 3.33. The court should exclude testimony such as blah, 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 bullshit. This is what she said at the grand jury. That's a range that we determine that there's not enough information to say or conclude one way or another about someone to be a contributor. Ridiculous. More importantly, Mr. Colbert has disclosed that through further independent laboratory testing, he is eliminated as a contributor to item 13.1. When Mr. Colbert sought to overturn the grand jury indictment, He argued that Miller's testimony was inadmissible and misleading. The state argued that the testimony was presented to the grand jury as exculpatory and in an effort to elicit favorable evidence from Mr. Kohlberger. These people are sick. These people are motherfucking sick. Just their lies. They're absolute lies. I don't know how people function in this world. You guys, do a shot. It's a Sunday, isn't it? This is the fucking mental gymnastics that these fucking people do and say. This is, what do you mean we put this in here to help him? Fucking A. You know what would have helped him is to have Molly testify at the goddamn grand jury. That would have really helped the fucking grand jury. Hear Molly. But fucking shit. I'm dead. I'm sorry, but fucking welcome to Idaho. Welcome to Idaho. You know, come as you are. Leave without a piece of your DNA. We keep that shit. You know, fuck. Come with all your rights. Leave with none. You know, fuck. 5 months. I'm so proud of myself. This is all just crazy. Yeah, it's pretty wild. You know, Allie Tally says 5 of you guys need to become members here. So if you turn green, Allie Tally was on it. Terry Dawn, welcome membership. Hoffy Master, what is up? Good to see you. 5 Truth and Transparency memberships. Uncensored Cyclone, 2 months. Welcome. You've been enjoying yourself? That's good. Brandy, what's good? Member for 16 months. OG. This is some wildest shit. Appreciate your hard work, man. Thank you so much. This is wild. Don't even know what I think about it. Because now we have the crime scene photos. We have Ethan missing. You know, he's basically like just nobody knows where Ethan is. No one's talked to him. People are calling him. He's not answering. You know, and here when we really want to think about it, let's talk about, I don't know, Maddie's fingernails. Of interest is that when a likely ratio was calculated for Ethan, the lab reported 3.33. And remember, they started that Kruger Den, what was it? That group chat. Talking grand jury bullshit. More importantly, Mr. Kohlberger has disclosed that through further independent laboratory testing, he is eliminated. Like, his fingernails are not under Maddie's, but Maddie's fingernails have, you know, they're saying, hey, hers, 2 others, though. When Mr. Kohlberger sought to overturn the grand jury indictment, he argued that Miller's testimony, this was part of the inadmissible shit and misleading. And then these bastards say, whatever, man, the grand jury heard that shit as exculpatory. Okay, just like that fucking the phone shutting off at 2:48, that was exculpatory too. Conclusion, guys. A fair trial is mandated by Mr. Kohlberger's federal and state constitutional rights to due process, a fair trial, effective assistance of counsel, and confirmation of witnesses. You know, what is going on here? Then they show, here's report 7. Date evidence was accepted was on 11/18. Suspect, Jack Decor. Suspect, Jack Decor. Just grow up, Jade Miller. Gonna go in there and get used like that. Suspect, Jack Decor. For us to see that on a piece of paper right here. Suspect, Jack Decor. Subject, Bethany Dylan Jose, Madison, Xana, Ethan, Kaylee. Suspect Jack Decor. You guys, they saw he had no bruises on him and he had nothing on him, right? You have Van Leuven. Van Leuven's like, look at this call right here. Look at this. You guys, if Jack Decor had anything to do with this, why are everybody calling him? Who the fuck is Jose Cruz? Oh, that was WSU. That's even more evidence of WSU's involvement. This is WSU's involvement because they're like, oh, hey, we had some guy break into some girls, you know, and they got that on 11/16. So submitted swab from F2 bedroom floor, submitted swab and debris. Remember? Swab of right fingernail clippings from Ethan. Where is Maddie's? 16-1. Swab of the left fingernail clippings from Kaylee. What? Kaylee? The DNA profile obtained from item 3 matches that obtained from the known reference sample of Xana. This DNA profile is at least 12.5 septillion times more likely to be seen if Xana Kernodle is the source than if an unrelated individual randomly selected from the general population is the source. The DNA profile obtained from item 6.1 indicates that a mixture of DNA. Xana is a potential contributor to this DNA mixture, assuming a 2-person mixture, and that Ethan is a contributor. This DNA profile is at least 19.1 times more likely to be seen if it were the result of a mixture of DNA with Ethan and Xana than if it resulted from Ethan and an unrelated individual randomly selected. Doesn't mean shit. Madison, item 11. Kaylee, item 14. Jack Decor, item 17. Bethany Funk, 18. Dylan Mortensen, item 19. John Showalter, item 1. Cole, item 2. Jose Cruz. They're all excluded. Like, boom, out the gate, excluded. The DNA profile obtained from item 7.1 is consistent with that obtained from the known reference sample of Ethan. What's 7? Well, it should be his then. It's his fingernails. The DNA profile obtained from item 9.1 indicates a mixture of DNA with a major profile, which is consistent with having come from Xana. Ethan Chapin is a potential contributor to the minor component of this mixture, assuming a 2-person mixture and that Xana Kernodle is a contributor. This DNA profile is at least 6,150 times more likely to be seen if it were the result of the mixture of DNA with then results of Xana and an unrelated person. Jack Decor, John Showalter, Cole, and Jose Cruz are excluded as being contributors to the DNA mixture. The DNA profile obtained from item 10.1 indicates a mixture of DNA with a major profile, which is consistent with having come from Xana. 10.1, I think those are her fingernails, right? Yeah. Ethan Chapin is a potential contributor to the minor component of this mixture, assuming a 2-person mixture, and that Xana Kernodle is a contributor, and that she's even the contributor. This DNA profile is 8 million times more likely to be seen if it were the result of a mixture of DNA. Wow. Jack Decor, John. Out. The DNA profile contained Maddie. Okay, Maddie. The DNA profile obtained from this item 13.1 indicates a mixture of DNA with a major profile, which is consistent with having come from Madison Mogan. Kaylee Gonsalves is a potential contributor to this mixture, Assuming a 3-person mixture and that Maddie Mogan is a contributor, this DNA profile is at least 77 million times more likely to be seen. Based on the likelihood ratio results, this is where it was. 0.3 is an inclusive whether Jack DeCore is a potential. This, and then it's like, whoa. Based on the likelihood ratio results is this. It is inconclusive whether Ethan is a potential contributor, but like, look at that jump from all this to this. What about where's Dylan? They didn't test Dylan here? What? You have Jack DeCore, Cole, Ethan, Xana, Bethany, John, Shoulder, Jose, Dylan Morrison are excluded as being contributors to this DNA mixture. And that's under Madison Mogan. I wonder if it's because Ethan got the DoorDash from her and Maddie had it at 250. The DNA profiles obtained from items 15 and 16 are consistent with the obtained from the known Reverend Kaylee. No DNA was detected on item 4. What was item 4? Yep. Submitted swab and from floor 3, bedroom floor. Huh. No testing. We got nothing on that. And then remarks. Oh, thank you, Jade. Thank you for your service. Dated evidence. 12/27/2022. Suspect. Wait a second. Brian Kohlberger is the suspect? Everybody else gone. The suspect is Brian Kohlberger, and the date evidence was accepted on 12/27. I thought that they... What was it? 12/27 should be... What was this stuff right here? 100 to 110. That's on the 6th. 12/27. Submitted swab from north wall of stairwell. Submitted swab from half wall. Submitted swab from second floor table. Submitted swab from second floor outside of bedroom. Submitted swab from living room table. Submitted swab from third floor door. Submitted swab of stain on floor near west bedroom. North wall of stairwell. Half wall. Second floor table. Interesting. That should tell you what they were looking at to try to get that with Brian. The DNA profile previously obtained from item 1.1. Okay. Serial print report issued on 11/20. Matches that obtained from that known reference of Brian Kohlberger. This DNA is at least what? Well, what the fuck? How is this on here? Yeah, we get that was put in on January 6th. These are likely ratios. But why would you have to compare it like that? The DNA profile previously obtained from item 1.4 indicates a mixture of DNA with a major profile. Assuming a two-person mixture, Brian Colbert is excluded. So there he is, the other male contributor on the fucking sheath, right? The DNA profile previously obtained from item 6.1, report 7, issued on this day, indicates a mixture of DNA. Assuming a two-person mixture, Brian Colbert is excluded. Brian Colbert is excluded. This is the day of Molly McMichael. Molly McMichael Day is 11/23 for the record. That was Molly's interview. Just calling it Molly McMichael Day. Look at that. Oh, that's not. You're not. There we go. Assuming Brian is excluded. The DNA profile previously obtained. Molly McMichael Day. Brian, it is inconclusive when Brian. Oh yeah, because this is the whole. What the fuck is this? This is that likelihood ratio shit. Brian Colbert is excluded, so he has been since excluded. Brian Colbert, due to the low-level results and limited data, no conclusions can be made regarding the minor contributors to the what? To 30. 12/17. What the fuck was going on in 12/17? Brian Colbert is not the source of the major DNA profile for this item. Is not the father. Brian Colbert is not the father. The partial DNA profile previously obtained from item 40. Brian Colbert is not. Assuming Brian Colbert is not the source. Jeez. Assuming a two-person mixture, the DNA is at least 7% more likely to be seen if it was resolved mixture from Kaylee Gonzalez and an unrelated random selected individual than if it resulted from two unrelated. Item 72. Madison Mogan is a potential contributor to the minor component of this mixture, assuming a two-person mixture. Ethan Chapin is item 5, Xana is item 8, Jack DeCourse item 17, Bethany is item 18, Dylan Morrison's item 19. Jack Showalter item 1, Cole 2, okay, Jose 33. Henry Clark. Kenneth Anderson. Remember all these names? It's like, who the fuck are these people? Mason Barstow, Jeremy Reagan, Coy. Who the fuck is that? James Deskins. Connor Chestnut. See item 6. That's how early on they got that. And this is, oh my God, look at this. Is holy shit. Here it is. M20224871. This case right here, they opened for him. Report number 3, issued 12/14/2022. And Brian Colbert are excluded as contributors to this DNA mixture. So Madison Mogan is a potential contributor to this minor component of this mixture, assuming a two-person mixture. So who is Madison Mogan's DNA mixed with? The DNA profile obtained from item 73 indicates a mixture of DNA with a major profile, which matches that previously obtained from the known reference sample of Kaylee. Assuming a two-person mixture, this DNA profile is at least times more likely to be seen if it were the result of a mixture of DNA with Kaylee and an unrelated randomly selected individual than if it resulted from the two. Maddie, potential. Ethan and all these people again. They are excluded as contributors. The DNA profile obtained from items 74, 75, and 78 matched that previously obtained from the unknown or the known Xana. The DNA profiles is not DNA profiles obtained from gender match previously obtained from the unknown reference. Keely, this DNA is at least 10,000 times. Okay, blah, blah, blah. Unrelated random person. Yeah. The DNA profile obtained from items 101 blah, 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 are consistent with that obtained from the known reference sample of Brian Kober, which is at his apartment. Item 108 was previously returned to the submitting agency. All remaining items have been returned to the main laboratory. Item 108. Wait, 108 is the fucking 108. That was returned to the feds. Item 108 was previously returned to the submitting agency. Who submitted it? Moscow. All remaining items have been returned to the main laboratory. Evidence vault for return to the submitting. Why? Item 108 was previously returned? What do you mean previously returned? What the fuck? What is the chain of custody on that? That's Brian's DNA. You guys, what the fuck is happening here? Hey, give us that back right now. The other stuff, whatever, but we need that piece, right? We're going to take that right now. The word sound is off the charts. What the fuck is happening? What am I reading? You guys, wait, what? Item 108 was previously returned. Well, there has to be. What? When? She wrote this report. It's dated, issue date is 2/6/2023. God, Jade Miller, why do I just have this feeling that you're just fucking shady as all get out, girl? That is the swab. That's his swab. That's like when he was arrested, he was swabbed. You guys, I have no idea what the fuck is going on, but these people in this case are wild. Jenny was a member for 9 months. What is up, Jenny? Allie Tally gifted 5 to the transparency memberships. She says, you get a membership. Brandy J's like, you get a membership. 5 memberships. Allie Tally's like, you get 5 memberships. Well, you know, a round of people. What is up, Kay Schmidt? What is up, girl? You get 5. Everybody's going to get green here. Officially over 1,000 watching. Make yourselves known. Hit the thumbs up or the thumbs down. You have an opinion. Make yourself known. Member for 38 months. Truth seeking. Congratulations on 73,000. Thank you so much. Appreciate that. Remember, tomorrow morning, if you get up with us at 9 a.m., we are going to, it's a 30-minute, about 35-minute trip to the Ohio Reformatory for Women in here in Ohio, in Marysville. Just so you guys can see where Sharilla is spending her time. Just Jackie, member for 27 months. Hello, everybody. Welcome. This case is crazy. If people that think that it's not, there is more evidence against Karen Reed than there ever physically has been against Brian Kober all day, every day. And I'm just like, well, what do you mean? They just, item 106 was previously returned to the submitting agency. Why? Why? Absolutely crazy. Can't wait till the AM either. Yeah. Also, everybody that went to CrimeCon, hope you guys had a good time. Anybody that was watching it on different people's channels, hopefully you guys were entertained. CrimeCon next year is going to be in Orlando, Florida, and we are going. We're already setting everything up. We're gonna do yeah. I'm still floored that it's 2026 and Kaylee's phone isn't unlocked. Yeah, we talked about that. Horlando is what I call it. Horlando. Here we come. Horlando. Horlando has some of the amazing strip clubs in the world. Horlando. Tails and Tails. Oh my God, Susan, you do need to be green. Best of luck, Susan. Best of luck there. Remember, the way that you get gifted those memberships is you have to like turn it on somehow. If the mods know, just give a little walkthrough. I don't even know. I think you just have to like hit a settings. So well, I did throw some bombs this week with Molly. It is official though. Look at Molly's DNA was never taken. Nobody in Molly's orbit of men, their DNA was never taken. Molly's dog was never like tested to see how it barked. Molly just does whatever the fuck she wants, and it's okay. I put out on the channel's community page, I showed you guys, dude, you know what? We're going to call Jack in the Box right now. Fuck it. I want to know if they have, what do I know? I want to know if they have cameras, and I want to know if they're working. Okay. And I want to know if Molly is still door dashing. And I want to know what their protocol is on why they would ever throw away food. Jack in the Box, Washington, Pullman. Call. We're calling. What the fuck? You guys, they have plenty of cameras. They have cameras. They've always had cameras. I went and looked through the WSU. I mean, WSU was involved so early on. So is Pullman Police. I don't understand how you could call in an order without paying. What do you mean? We're going to a trip to prison. Yeah, it's tomorrow. We're going to go to prison. Trip to prison. Mm-hmm. I love when you have the balls to make calls. Yeah, I have the balls to debate people too. Turtle Boy's a pussy. He refuses to debate me. Melanie Little, all of them. Nobody will debate me in the Karen Reed case or Aiden Carney case. Aiden doesn't even know his own case to debate me. So, but he asked a while ago to come on my channel. And I was like, the only way that I would have you on my channel is if you had a lawyer present, because I just feel like you would definitely incriminate yourself based on my questions. He would go hardcore nosedive. And so, yeah. But all of those fucking people on Twitter just cry all day. Just a fucking cry fest. A cesspool of misinformation and just drama. But yeah. So... But yeah, nobody wants to talk about the timeline facts of any case. If it's a case I cover, I'll be happy. And you guys, for the record, a debate is like a conversation. Like, let's have a conversation about this. Here, let me ask you some questions for you to try to set the record straight, but I'm not going to let you gaslight me or the audience. So once you start saying something that's just not true, I'm going to call you out on that. I'm going to say, okay, where are you getting that information from? Show me that. So yeah, it's a cry fest over there. But call Molly. You know, we're trying to still figure out if Molly's homeless or not. So Molly is like MIA. What's up, Bubbly Waters? How you doing? Gary claims there's 420 cameras on WSU campus. Interesting number of cameras, probably. Gary Jenkins is a liar. Curtis Whitman lied about why he left work on the night of the murder during the murders. I mean, WSU is just popping off. They one of their fraternity members, he, according to the campus police, hung himself the day before the quad homicide on Moscow's campus that were fraternity and sorority related. But the catch here is that the night before, Maxwell Pitts was pulled over and given a DUI. But then if you go and look up his records, you can't find that anywhere. But we found the report. We found the information that it was in the records and then it got taken out. So why would anybody, and I get it because it couldn't be adjudicated, so it has to come out like that. But I think somebody should really look into that. Again, on WSU's campus, there was somebody that took their own life. He was a member of one of the fraternities. And the night before he did this, he was cited for a DUI. And that's really similar to how they get CIs in the community, is they get you for like a DUI or something like that, and then they make that stuff go away if you do stuff for them. So that happens 11th and 12th, and then 12th and 13th, 4 kids are stabbed to death on the University of Idaho campus. Again, all Gary Jenkins wanted to know is, hey, can you tell me if those are, fraternity and sorority related? What? Yeah. Oh, okay. Why? If your death on your campus was a suicide, why does it matter if the deaths in Moscow, who they are affiliated with? Think about that. Why would that be your only and first question? And that's very interesting to me. Why would that be my first question, is to ask them, hey, did they have anything to do with fraternity or sororities, those victims? Who cares? Why does that matter? That's a homicide. Why does that matter to you? Oh, well, because the Greek community lost a kid over here at WSU's campus. Oh, Truth and Transparency, what prison are you going to tomorrow? We're going to go take you guys on a tour, a trip over to where Mackenzie Shirilla is being homed. It's the Ohio Reformatory, Women's Ohio Reformatory in Marysville. It's not that far away from where I'm at, so I'm doing it for all of you guys that have been following the crash, and it's just been a really big talking point. Some people don't understand how to talk about, the judicial system with it, but hey. But it's at 9 a.m. So Love asked that too. Confused. Yeah, I'm just gonna go touring some prisons tomorrow. If you guys want to come. I'm just taking you guys on a field trip. So come live if you want to watch live, watch it on replay. But at 9 o'clock in the morning, I'm going to take you guys to Marysville for it's gonna be like a 30-minute drive We'll show you guys where the prison's located. We'll show you where Mackenzie from the Netflix case is being housed. And we really want to point out online that this is to rehabilitate people, okay? And it's a very updated venue, location. So it could be potentially her forever home. She's serving 15 to life on 2. They weren't consecutive; they were concurrent, but 2 murder charges for her Dominic and Davion. So this is not. I'm not going to the crash site. That's in Strongsville. Okay, she got sent a little bit south, like 2.5 hours south of Cleveland, to a place called Marysville, Ohio, outside of Columbus, and that's where she's been living since she was sentenced and transported. But if you go online and you look it up, it's a rather nice and new facility. So, all right. So that's tomorrow morning at 9. I am going to attempt to do a call-in show. And the topics are any cases that I cover, as well as if you went to CrimeCon. So if it's a case that we cover here, let's talk about it. If it's not a case I cover, I mean, I'm not going to have an opinion on it, but you can go ahead and for your 2 minutes talk about, I want to talk about Shanna Gardner. I think there's going to be a lot of evidence tossed in the case. There has been a ruling on Henry Tenon and what can be even used against him. It's still under seal. This week it should come off the lift because we went ahead and requested that. So we're going to find out if anything to do with Henry Tenon's plea deal gets to be mentioned to his jury. That's going to happen one day, But, yeah. You calling Jack in the Box made me think of the time you called BWW saying you thought your boyfriend was cheating and seeing if they had overnight training. Yes, BW3s. I called them. I went to BW3s for that. When I thought my boyfriend was actually cheating, the people I called for that, though, that was in the Charlie Kirk case, because we got some really good information in the Charlie Kirk case right off the rip. But that was when I called Jiffy Lube. I called Jiffy Lube, and I wanted to know if they had cameras, because and if they were working, and if I could get my hands on some cameras, because I felt that my man was lying about getting an oil change while he was getting rim jobs. That's right. So I probably said something like that. And then that girl, oh my God, she was like, oh, hell no, I will definitely help you, girl. I was like, that's what I'm talking about. Us girls need to stick together. These men out here cheating on us, getting rim jobs, going to Jiffy Lube. So, all right, guys, you guys all rock. Again, we're getting more information from Hippler. I guess it's going to start kicking a high gear. I know Annie Potts had called saying, hey, when is this stuff getting released? And it was like they had to claim that they did a ton of redactions, not like a ton, but they had to go through all these documents and make sure whatever was supposed to be redacted was redacted. So they were doing, extra checking of that. So we just got some on the 29th, which was Friday. They like to do their little releases in clusters right around each other. So I'm thinking that maybe we're going to get some more this week. Hopefully we do. CO Day. Is that how I'm saying it? Oh my God, yes, LOL. She was ready to help a sister out. I know, right? If anybody is I have a friend in Moscow that, Molly, are you okay? Can you blink twice? We will house you for a week. We'll make sure that you are living large and in charge, Molly. We'll get you in a hotel for the week. We'll make sure that you have food. Molly, we need to talk. Okay. We just want to know how it was that you got pulled over while you were a witness in this case, and Payne acted like he didn't know who you were when he rolled up to your car, Molly. These people acted like they didn't know who you were. And you're the DoorDash driver. Hello, you the shit. And when they would pull you over and arrest you and shit, and then you just never ever got in trouble, Molly. Molly, you're supposedly like on all these drugs. You're supposedly like a drug user and seller, and you are the star witness in the Brian Colbert murder case. And yet nobody knew of your existence. And then all of a sudden, there's only been ever one eyewitness until almost 3 years later when Molly comes out and says, I am the DoorDash driver. I saw Brian. So Molly, we want to make sure that you're doing okay. Get it out to Molly. Do not make you put up a billboard out there in Latah County. Vote for Molly McMichael, the next mayor of Latah. I mean, maybe we need to do that. Maybe Molly will be like, what the fuck is this billboard? Guys, what if I buy a billboard for Molly for a month? Molly. Vote Molly. Okay? Vote Molly. Vote Molly McMichael as your next councilwoman. Can you imagine that? Star witness help Bill Thompson secure a plea deal. Okay? Or Molly McMichael's day, and it should be the plea deal day because Molly McMichael made that happen. Let's buy a billboard. Okay. I wonder how much they charge in Latah County. It can't be that much. Jenny's like, hell yeah. Fuck that president. Let's go for president. Vote Molly McMichael. We have to do something that's a little believable here. Vote Molly McMichael, your next councilwoman. Okay. Your next substitute teacher. Molly McMichael, you don't even need a degree to be a sub. Okay. I don't think that you do. Maybe you do. Damn it, Molly. How about a bus driver? Vote Molly next bus driver of Moscow of the Latah County School District. We just need to vote Molly for everything. Molly McMichael for sheriff. Fuck it. It's on. Everyone gets a ride with Molly. Vote Molly, you're next. Yeah. I mean, anything. Vote Molly for vote Molly McMichael for everything. We need to be creative. I think Molly for mayor is great. I just got here. What did I miss? Well, Molly is going to run for mayor and she doesn't even know it. When's the next election there? Let's even find out what's on the ballot. Maybe we can make it seem like Molly is running against Ashley Jennings. Can we do that? Is there any laws against that? All right. Let's do this. All right. You guys do your job. Molly for council, Molly for everything, Molly the whistleblower. Find out what's on the docket next for them to vote in. Let's get her fucking on the ballot, bitches. Okay. For Molly's billboard, Lana, you're amazing. If Molly does not get on a billboard by the time that school starts, I want Molly on a fucking billboard. All right. And I want a very nice picture of her. None of these pictures that show her like how y'all make your little thumbnails. I want a nice picture of Molly. And if you can't do that, then don't even submit it to me. All right. Molly needs to look fresh as fuck. All right. Molly the goat. Molly for goat? What the fuck? Molly 2026. We need to have her running aside with somebody else. Make it President Molly and Jennings. Like, man, we will find a nice picture for Molly. All right. She's not going up on one of them billboards looking half-ass. All right. And then my other billboard is going to be Jennifer Drake got away with murder. Okay. Please investigate Jennifer Drake. Jennifer Drake. We got to get a billboard up for Jennifer Drake. Jennifer Drake. YouTube's most wanted. Somebody says, you guys definitely have billboards out there in Athol, Idaho. Hold your tongue. Athol, Idaho. Okay. I've been to Athol, Idaho. I've been to all those fucking little towns in Idaho. And By God, I've seen billboards. Molly will fight crime. Athol, Idaho, where anything fucking goes, okay? Molly gotta look fresh and professional. We're not doing ho-fashional shit here, Molly, even though we could totally have fun with it and we can call it a ho-fashional. Molly, Molly, we love you. Molly, we just want to know, how much pressure did the FBI put on you? Molly, how many times did you interview before the one with Payne? Who told you what to say, Molly? Molly, how many vehicles were you driving? Molly, who were you hanging out with that night? Molly, who do you know at the Whites? Molly, where is your phone? Where did you put it? Even though you got a new one, what did you do with your old one? Did you destroy it? Molly, why are you talking about panties in the middle of the street? Where are your panties at that night, Molly? Molly, why the fuck would you walk around for 15 minutes? You would never, right? Molly, why are you lying? Why are you always lying, Molly? Nobody cares. Nobody cares about your lies. Molly, blow the whistle on this motherfucking shit. You can be seen as a hero. Molly, they don't care about you. Molly, look at how they treat you when they pull you over. Shit, you saved the day for Bill Thompson. You saved his legacy, okay? You should be able to be on any tit and sucking off of it, the government's tits, for the rest of your life in Idaho. Molly, you got the plea deal. So, she don't know shit. Guess what? And if she says that, now wouldn't that be something? Hopefully she says that. Molly's over here remembering that there was panties in the middle of the street 2 weeks after talking to the cops when she supposedly, I mean, how do you remember that? You know how many nights you DoorDash and how many different things would like, oh God, was that this night or was that that night? But God forbid she, panties. Molly cannot forget the panties. Molly. Molly. I want to show her pictures of everybody in the law enforcement that worked undercover that night. Molly, is this who you saw that night? I mean, why are you saying that you saw Brian? Brian doesn't have fucking spiky red blonde hair, Molly. What the hell, Molly? Why did you let Payne tell you that a car pulled in behind you? Makes no sense. Molly, did you know that they put a pen, trap, and trace on you? Molly, who were you with? There was another phone with you that was moving like with yours. They were really interested in two phones. And that would make sense because, Molly, you have multiple phones, don't you? Most drug dealers do. Molly, are you a mule? Molly, when's the last time you said courtyard? Molly, there's never shootings. Nothing ever happens in Moscow, and yet you show up every time like there is something that goes down. How's that possible? Molly, you are the trilogy of Moscow. Every time something goes down, you're there. It's like Candyman, Candyman, Candyman. Molly McMichael, Molly McMichael, Molly McMichael. Boom. Molly, I just don't want to see you keep getting screwed. I know that your friend passed away. Did you guys know that? That Jimmy guy, he's dead. Jimmy is dead, Molly. Jimmy cannot die in vain, Molly. Jimmy is dead. You guys know that? Jimmy's dead? Do you guys know that guy that came and picked her up? He's dead. Jimmy is dead. You guys didn't know that? Jimmy's dead. No, he is dead. Oh, he is dead. Is it Beetlejuice? Candyman, Candyman, Beetlejuice, all the same shit. No, Justin Stringer. Yeah, he's dead. What? Not Jimmy? Justin? I think it's Jimmy. Hey, how about this way? It doesn't matter. One of those motherfuckers is dead. Okay? Molly. What the fuck? Come on, we just talked. You guys don't know that one of her friends died? I think it was the kid that had cancer, right? Didn't one of them fighting cancer? We care, Molly. Call Lana. Justice for Molly. The second husband, I'm telling you, one of her men died. Somebody is dead in Molly's orbit. Somebody died that had fucking, that knew. The next person, Janelle, where are you? Let's talk about your dad. Everybody, let's just, Janelle, Molly, I'm friends with Bill Thompson, Mike Michaels. Molly changed her name to Molly fucking Thompson. You guys didn't hear about that? Molly changed her name to Molly Thompson, and fucking, I think Bill Thompson's wife is losing her mind. She thinks that they have a thing now together. But I'm not. I'm being serious. Molly's friend, boyfriend, I don't know, pimp. That dude is dead. He died. It's sad. Molly Thompson, put it on the billboard. Molly McMichael Thompson. All right, guys. You guys rock. Molly had a gun. Oh, so have them start singing it. Yeah. Remind yourselves, Bill Thompson does play in a band, and he's probably going to be out and about this year. We did have the pleasure of seeing Bill Thompson playing Layla. You got me on my knees, Layla. I'm beg you, darling, please, Layla. And we also had him playing, I don't know, I put those videos a long time ago. So if you guys see Bill Thompson out this year strumming it, you know, tip, make sure you tip. Put money in the tip jar. Ask him how Molly is. They're friends and all. Ask him how Molly is. So I want to know more about Janelle. Who doesn't? You know, I can't believe there are not more boots on the ground in that area between Pullman and Moscow. I can't believe that nobody is, hey, yeah, I want to talk to Eric Gower. Eric Gower, like, come on. Jack Decor. I think Jack Decor should sue. If I was Jack Decor, I would sue all these motherfuckers. All of them. All right, guys. We'll see you on the next one. Thank you guys so much. We appreciate you here. Moderators, you guys rock. Give a thumbs up or a thumbs down on your way out. See you on the next one.